Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for oral argument in 1 CV 23-0520, Ellen Fong versus City of Phoenix et al. As a reminder, the hearing is being video and audio recorded, and in a few days will be posted to our YouTube channel. Counsel, before you begin your argument, please identify yourself and the party you represent. Each side will have 20 minutes to present your argument, which means the appellees will divide the 20 minutes between them as they choose. If the appellant's counsel would like to reserve time for rebuttal, you're required to keep track of your own time. We have read the briefs, conferenced the case, so we are familiar with the issues. It's not necessary to repeat what's in your brief. So with that saying, counsel.
Good morning, Your Honors. My name is Tom Sherrill, and I am counsel for appellant Ellen Fong, who is actually here with us this morning. Ellen was very seriously injured on Sunday, December 6, 2020, when she accidentally rode her bike into an open trench that was in the bike lane on Washington Avenue west of 10th Avenue. Ellen claims that the city was negligent for failing to guard or protect the open trench while the work crew was at lunch. And she claims traffic aid was negligent for failing to close the bike lane. Ellen's case is about an open trench in an open bike lane. Her claims are separate and distinct as to the defendants. Specifically, Ellen claims that the city acted unreasonably when its work crew left the work site that afternoon for lunch, leaving the trench or hole in which they were working wide open, as is depicted in appendix page 198 and 199, part of the police photos. Ellen also claims that the city acted unreasonably when the employee whose responsibility it was to protect the hole, the single employee that was left behind, did so while sitting on a backhoe that actually cast a shadow obfuscating the hole as depicted at
Counsel, let me just jump ahead a bit. The court granted summary judgment finding expert testimony was necessary. What's the standard of review?
Well, the standard of review for determining if expert testimony was required is abuse of discretion. But the court's refusal to permit expert testimony was premised on the application of incorrect legal principles.
So is it de novo then?
It is de novo. This was not a professional negligence claim. There was no specialized education or knowledge required.
I'm sorry, counsel, I'm just confused. You said it's abuse of discretion, then you said it's de novo. Can you clarify?
My understanding, Judge, is that the review for summary judgment is de novo, that the court looks at it de novo. The appellee has cited a number of cases which concern the court's decision in regards to whether to permit expert testimony in a certain setting, and that is a discretionary standard. But because those decisions were premised, or we contend they were premised on incorrect legal principles, we believe it's a matter of law.
You're saying the decision whether expert testimony is required, you would say, is a de novo review?
Correct, Your Honor, based on legal principles. And regardless, the discretion is not unfettered. We maintain there was an abuse of discretion here when the court refused to permit the rebuttal opinion of our expert. The common sense that Your Honors relied on when you reviewed those photos that no doubt led you to conclude that the open trench was dangerous, that there were no barricades or cones or covers put before it.
But
That-
there was a barricade before blocking off the lane, right? Your client did right around the barricade.
The barricade was at the intersection, which is where all the barricades were. There were no barricades in the bike lane. All of the barricades were part of the temporary traffic control plan to channel the motoring public to the single
But you're
southbound
saying the
lane.
barricade did not block the bike lane.
I'm saying that the barricade did not block the bike lane. The barricade fortuitously straddled a portion of the bike lane, but the barricades were placed at the intersections of
You're
7th.
saying it straddled the bike lane. So it did block part of the bike lane?
Technically, Your Honor, it blocked part of the bike lane at the beginning of the intersections. It really was intended to channel the cars, and it's located at the intersection, so the channels or the barricades were next to each other, parallel. There was not one barricade in the bike lane between 7th and 8th, between 8th and 9th, and between 9th and 10th. Again,
Were there any bike lane specific signs anywhere at the construction site?
None. And we maintain that the traffic barrier manual, the city's own traffic barrier manual,
Could I just clarify, when you're saying at the scene, is that close to the hole, or were there some
No.
signs involved? No,
sorry, Judge,
No
there were
bike lane.
no bike lane signs.
anywhere even a mile back or any other?
Correct.
Okay.
There are 3 bike lane specific signs required. That's at page 173 of your appendix. The traffic barrier manual states, anytime the bike lane is closed, proper signage shall indicate, quote, bike lane closed ahead, quote, bike lane closed, and quote, bicycles may use full lane. All 3 of those signs were ordered. All 3 of those signs were required. None were present.
Counsel, you just referenced the manual. Do I understand your client's position correctly that the manual provides the standard of care?
Yes,
Doesn't that cut against your position, though, then that an expert is not needed to set forth the standard of care? If the standard of care is in the manual,
it's 1 page in the manual. The trial judge based her decision on a belief that a jury would need to review hundreds of pages of the manual for uniform traffic control devices, often referred to as the MUTCD. The court was simply wrong. We have no MUTCD claim. Ellen's claims were not that the temporary traffic control was engineered wrong. In fact, Ellen's claims had nothing to do with the MUTCD. There weren't hundreds of pages. There was 1 page in a traffic barrier manual that was published by the city that said, you shall place these 3 signs if you intend to close a bike lane. Those 3 signs were ordered. Those 3 signs were not picked up, and none of the photos that you have before you and that we have depict those 3 signs.
Do you agree with the Utah decision, the United Fire Group case? I mean, it seems to say if there's no signs anywhere, and maybe your position is there's no bike signs anywhere, that you don't need an expert. But do you agree with the general notion that the Utah case says if there are some signs, then you need an expert to help the jurors?
No, I don't disagree with that.
You do not disagree with that?
No.
But so wouldn't the response then be, but there was a barricade, that is a sign of some kind. It doesn't specifically say bike lane, but it certainly puts people on notice that there is a hazard ahead. If it's straddling the bike lane, wouldn't that fit within the Utah framework?
No, Your Honor. The Utah case, if you look at it closely, you'll see that there were signs and barricades in the Utah case. The claimant in that case entered at a point beyond which the signs were present and ended up driving off an open road that had no sign at the point that the road fell. our argument is there were barricades, temporary traffic control barricades, none of which are germane to our claim, none of which adequately closed the bike lane, none of which...
But that was the point here was there was a barricade at some point that your client saw and had to ride around. So that...
There were dozens of barricades.
Right, but that seems to be what at least under the Utah case would arguably mean there was some signage, so we need some expert assistance in that.
The difference is that here, and as in the Utah case, the absence of the sign or barricade before the hazard is what the court commented on. The court pointed out that there was nothing saying the road was closed where the road was closed. There were barricades elsewhere, and there were barricades here elsewhere. They were part of the temporary traffic control. Our claim has nothing to do with the temporary traffic control plan. There weren't hundreds of pages in which a jury would have to review in order to understand the claim. And our claim against the city has nothing to do with Trafficade's work. It's a separate, distinct negligence claim based on the actions of that work crew during the lunch hour.
But don't you also have a claim against the city based on Trafficade's work?
Vicariously, yes, Your Honor. And arguably, a judgment in favor of Trafficade would extinguish the vicarious liability claim. But what the court failed to recognize from our perspective, and the portion of the decision that screams for reversal, is that the judge found, with regard to our claim against the city, and she only addresses it in the last paragraph of the order granting summary judgment, there was indisputably someone near the hole monitoring it, which I submit as a comment on a factual issue. The question would then become whether this was adequate. Again, this would still require an expert to establish the standard of care. So the adequacy of the protection efforts is what the court maintains required an expert. The protection efforts included not putting a cone or a barricade at the hole, and it involved an employee whose responsibility it was to guard and protect the hole. He was eating lunch on a front loader, speaking to his wife on the cell phone when he observed my client approach. He didn't get down, he didn't stop talking on the phone, he yelled twice, she didn't hear him, and she ended up in the hole. There's no specialized...
You're saying there's a duty to have someone at the site of where the hole is to be watching for bicyclists. It seems like the more compelling argument is you need to warn people before they get there, as opposed to we're going to have someone at the site yelling.
No, Your Honor, I think
standard.
There's both. I think that Trafficade's negligence in failing to place the bike-specific signs failed to close the bike lane, and I think the city's actions during that lunch hour in failing to protect against the open trench. The work crew was in it.
If the accident happened at 5:30 after the work crew goes home, the city presumably doesn't have a duty to have somebody sitting on the tractor yelling warnings.
They wouldn't have left the hole like this at 5:30. They would have had an obligation to put a metal plate over it.
Okay.
Yes. It's just the fortuitous, for lack of a better term, occurrences during this lunch hour that we maintain were negligent. The crew left. They left this hole open. They didn't put an orange cone in front of it. They left one employee who admitted his responsibility was to protect the hole from bicyclists. And he chose to do so by sitting on a front loader, eating lunch and talking on his cell phone. There's no specialized knowledge needed for a jury to evaluate the reasonableness of that conduct. And we maintain that the summary judgment in favor of the city should be reversed because no expert testimony was required. Query what type of expert you would call to offer opinions about an employee eating lunch on a front loader who was responsible for covering an open trench or protecting an open trench. I'd like to save the rest of my time for rebuttal if that's...
Thank you.
Good morning, Your Honors. My name is Jonathan Yu. I am the attorney for the City of Phoenix, but I'll be arguing on behalf of both appellees today. The trial court's decision to dismiss plaintiff's claims for lack of crucial expert testimony was not an abuse of discretion and should be given deference in light of its well-thought-out reasoning.
So you believe it's an abuse of discretion standard of review?
Correct, Your Honor. The Warner case says that determining whether expert testimony is required is discretionary within the trial court.
And that was dicta, though, right? The holding of the Warner case was that the trial court erred by dismissing the case without giving the plaintiff an opportunity to cure. That's different from the standard of review, right?
I still believe that case put the issue of expert opinion in the discretion of the court, making an abuse of discretion here.
But the issue here is, does the plaintiff have enough evidence to survive summary judgment? Right?
Correct.
And that's an issue that's reviewed de novo, right? If summary judgment is granted on the basis of insufficient evidence, that's reviewed de novo.
Yes, but the finer point here in which the court resolved the motion for summary judgment is the need for expert testimony and whether or not that was failed to Ms. Fong's claim.
So would it ever be an abuse of discretion in one where there's absolutely no warning signs at all? You would just say that's maybe an abuse of discretion to require an expert under that scenario?
Well, under United Fire, if she decided that and there was a complete absence of signs, then I suppose that would be an abuse of discretion following the logic of United Fire.
But isn't there, the argument here is there were no signs that were specific to the bike lane. So why doesn't that still fit within that
Judge,
rubric?
you brought up a good point in Mr. Sherrill's argument is that there was not a complete absence of signs here. In fact, there were hundreds of barricades, lighted signs.
When you say hundreds, but in terms of if someone could access Washington from a point that's beyond hundreds of signs, we're mainly concerned with signs that are close. There doesn't seem to be an argument that there were cones right around the open hole. So it seems like there's still a question of was there a sign warning about the bike lane being closed?
I don't think there's so much a question about that. Ms. Fong herself has acknowledged that there were signages along Washington Street. The photographic evidence as well as the video evidence show signs not only along Washington's vehicular lanes of travel, but in the bicycle lane. I'm happy to provide you with those photos, but there are type 1 barricades in at least 3 spots along Washington, including 7th, 8th, 9th, and 10th just before the excavation site. So this is not a United Fire situation. There is a complete absence of signs, thus not requiring expert testimony. There are signs here, which then, according to United Fire, makes the issue a matter of sufficiency. Whether or not the defendant's traffic control design was sufficient.
But lay people read and interpret traffic signs all the time. When you're driving in your car, you don't have an expert to tell you what a sign means. You just read it and you interpret it for yourself. So why couldn't lay people on a jury look at the photos and decide for themselves, without the aid of an expert, whether it was sufficient to warn of the danger?
Because the requirements that Ms. Fong is kind of advancing as far as sufficient traffic design go beyond the knowledge of a person that's a member of the traveling public that may just may encounter signs occasionally on their morning commute. There are a lot of specific requirements as to
even an occasional, we expect people to understand signs. If they're not obvious to the person who's experiencing it for the first time, that would seem to be relevant. It seems like it's in the knowledge of the general public to be able to look and say, that barricade should have warned you not to keep going.
Right, but you must look at the minutia of Ms. Fong's actual claim here. It's that certain signs should have been placed at certain spots.
But doesn't that just go to the jurors? You just have to explain someone riding a bicycle should understand that a barricade means you should not continue going in that bike lane. But why isn't that something a reasonable juror would understand or need additional guidance on?
Because the claim here, again, is that there was a certain standard required in making these traffic control design plans.
But is the standard just you have to have it within X number of feet of the hole? It still seems like it's a...
Well, that's a great question, Your Honor, and that's a question that a juror would be wondering about when deliberating, and that's a question that would only be able to be answered by an expert here. The traffic control manual that they rely on is not as straightforward as they make it out to be.
Do you agree that the traffic control manual says you need some bike lane specific signage?
I agree that that's what's in the manual. I disagree that that sets the standard of care as they seem to suggest.
But do you disagree that there were no bike specific signs between the point where she entered Washington and ran into the pit?
Based on the photos and the video, yes, I agree that there were no bike-specific signs in that portion from 8th Street to the pit. Now, the construction zone was considerably longer.
But you're saying there would be an expert who would come in and testify that even though the manual says you need bike-specific signs to warn people riding a bike, it doesn't matter that they didn't have any bike-specific signs? That would be, an expert would come in and testify to that?
Yes, because there's also the issue of the sufficiency of the rest of the traffic control measures that were in place beyond the bike-specific signs, which her original claim, I should say, implicates. Ms. Fong's theory has always been, for the first 13 months of this lawsuit, that both defendants inadequately barricaded and warned her of the hole. That is it. Nothing about specific signages, nothing about where those signages should be placed. Only now that we've gotten to the appellate level and she's narrowed her claim, does she advance this theory and the reliance on the traffic barricade manual.
Counsel, the manual is not the standard. That's your client's position.
I wholeheartedly agree.
Is it relevant to the standard?
It is absolutely relevant.
What is the standard, and where do we find the standard?
The standard is going to be the standard needs to be set by the expert will have to opine on what the actual standard is, guided, of course, by the barricade manual. The manual itself acknowledges that.
Did you explain in your summary judgment motion what the standard is and how she did not comply with it? It seems like you'd have to say this is the standard.
Ms. Fong would have to say that that's the standard.
Okay, but you're suggesting that there's a standard. She's saying this is something. It's an open and obvious. It's something that anyone should understand. You should warn people, and your warnings were not adequate. I don't need an expert to say there's a giant. Well, let's say that the road is going and the road just stops and there's a cliff. We don't need an expert to tell us that you need to do something differently and warn people. You need to put a barricade before people run off the cliff.
Of course, because if there was an absence of signage on the road, a juror does not need an expert to tell them that something should be done. Agreed. That's not the case we have here.
Do you believe that the standard of care is different for the city versus Traffic-Aid?
I don't think so. The city, I acknowledge, has a non-delegable duty here to maintain the roads, and they contract that out to Traffic-Aid to kind of place barriers on the roads to make it safe. It's the same.
But if she says the standard of care is you need to provide adequate warning that a reasonable motorist or a reasonable person on a bicycle should understand that there's a hazard ahead. Do we need an expert to, do you dispute that would be the standard?
I would not dispute that would be the standard if that's what the expert said and it's consistent with the traffic barricade
There's no experts,
manual.
and we're just saying this is,
Yeah.
She's advancing a claim that you need to provide warnings that a reasonable motorist, a reasonable bicyclist would understand.
Yes.
Don't we just send it to jurors and say, put yourself in the place of a reasonable motorist, a reasonable bicyclist. Does this does this barrier put you on notice not to continue riding a bike there?
No, because there's a lot that goes into just the simple statement that you should have had a barrier here to protect me. What kind of barrier? Where should that barrier be placed? How many barriers? At what point before the hazard should those barriers be placed? At what location so the bicyclist can conform their actions and avoid the oncoming hazard? All questions requiring expert testimony, all questions not answered by the manual itself.
Well, I would agree that the manual is not going to cover every specific instance, but it still just seems to be a very general standard. Is this a hazard that a reasonable person would understand to signify that there's a hazard ahead?
I think that it's two separate issues then, Your Honor. Is this a hazard that she should be able to protect herself against? That does not require expert testimony. I agree with that. But her claim goes further. It's that you should have done something to warn me, something to protect me. And again,
I'm just not understanding how that's different. She's saying you didn't do enough to warn me.
correct. And the question then naturally becoming what should have been done. Ms. Fong can answer that herself, but she's not qualified to say what was actually required as a licensed traffic expert or as the city who owns the street. That's why you need expert testimony. And again, I want to emphasize the traffic barricade manual is not the silver bullet that she makes it out to be. Yes, there is one page in the manual that says you need specific signs, but the concepts in that one page require the jury to consider, for example, what a TRAX permit is, because bike lanes can only be closed with TRAX permits. That's Chapter 2, 13 pages. Then it says that bike lanes can be closed using vehicular warning and traffic signs. Okay, well that's fine, but the manual contains 32 regulatory traffic signs, 38 traffic warning signs, 7 types of barricades, Type 1 and Type 2 of varying heights.
Counsel, there's case law that in the pharmaceutical context that says a warning label on a bottle of medication, the adequacy of the warning doesn't require expert testimony because the consumer who's at home in the bathroom taking a pill, looking at the bottle, should be able to read and interpret the warning and understand the warning without the aid of an expert. And so a jury can determine whether that warning was adequate. Why isn't that the same here? If you're driving a car, you don't have an expert to help you interpret the traffic signs. Why can't the average juror look at the pictures and determine whether the warning is adequate?
Because I would posit that the warning label on a medication bottle is far simpler to understand and read than multiple traffic control measures on a strip of public roadway.
But how does that answer the question of we expect motorists to do that we don't give them an expert while they're driving. We expect a motorist to understand it. Doesn't it have to be as simple as the warning on a medication? We don't expect somebody to go hire an expert to read it and tell them what the warning says. Just like we don't expect motorists to consult with an expert before they drive a car.
Yeah, I think in the situation of the label, it's more self-evident to the person reading it what is required. But here, the issue that she's raised is the sufficiency of a entire design package of signs and roadblocks and barriers. And so, yes, maybe the traveling public can for itself determine what that says, but the issue here is whether or not that meets the standard of care under the traffic barricade manual and, the specialized knowledge of a traffic control
There's
specialist.
evidence that Traffic Aid ordered bike lane-specific signs.
It's true.
And that bike lane-specific signs were not present in the area of the excavation, correct?
Correct.
So isn't the fact that Traffic Aid found it necessary to order bike lane-specific signs an admission that bike lane-specific signs are necessary? And couldn't the jury say that you should have had bike lane-specific signs around the excavation?
Yeah, I wouldn't dispute that that's that bike lane specific signs were ordered and necessary at a certain location. But again, where those signs should have been placed, according to the standard, is what needs to be answered in Ms. Fong's case. And again, keep in mind, there are other traffic control measures that the jury would need to assess whether that was sufficient. The type 1, type 2 barricades, the arrows, the vehicle in front of the excavation site. Those are all things that still require an expert to say whether that met the standard of care.
Well, that just, it seems, I understand your point that even if you don't have any bike-specific signs, notwithstanding that they were ordered and not placed, you can have a barricade that completely blocks it, and it should be enough. If you have to ride completely around it, even if it doesn't say bike lane, but that still seems to simply be an argument that a reasonable person should understand not to go. If you're not going to specify bike lane is closed, the sign needs to be such, or the barricade needs to be such, that a reasonable person would understand that it's dangerous to continue riding in the bike lane. And that I'm still just struggling why that's not something a juror could assess.
I think it's because that issue kind of wades into the subjective belief of Ms. Fong and what a reasonable person would believe when they see the signs. And that's not
Well, it's not her subjective belief. We're just saying, would a reasonable person understand this barricade to be a warning not to continue in the bike lane?
Right. I think a juror could for themselves determine if that was a warning that would put them on notice. But I think it's a slightly different issue when she is raising the issue, when she is saying that the city's design plan was insufficient and inadequate for certain reasons. That's where you need to bring in an expert. And again, United Fire. This is something the court's already said. Traffic control design, the sufficiency of certain things being done or not done, is not within the common knowledge of a juror. And certainly this case falls into the latter scenario of United Fire, where there is at least some traffic control in place, making the question a matter of adequacy and not just within the common knowledge of the juror to say, yeah, I would have seen, had I seen this, I would have been on notice of the oncoming excavation.
Counsel, a question going back to some of the earliest questions that were asked, and Warner aside, and Judge Kiley's concern about Ditka there in Warner, what's your best case that says something other than expert testimony is required to prove a plaintiff's, expert testimony is needed to prove a plaintiff's claim? That's reviewed de novo. It's a question of law. So you're saying Warner says it's not a question of law. My question is, what's your best case other than Warner that says this is not a question of law?
Your Honor, I apologize. There are other cases in Warner that we cited in our response brief. I just don't have them committed to memory right now.
Is it fair to say that there are other jurisdictions, and maybe even a majority of them, that say this is a question of law, whether an expert is needed to prove a plaintiff's claim?
Yes.
That's fair to say?
I would say that.
Thank you.
That's all I have, Your Honor. The trial court's ruling here, I think, was a well-reasoned one. Now, maybe a court in a different day with different facts would decide it differently, but it's important to remember that.
I'm not following that, though. If you're saying someone might conclude that there's enough to put a reasonable person on notice, that seems like that's what the jury is for. If you're just saying the judge, it seems like it should be a matter of law whether expert testimony is required under these circumstances, and that I'm not following exactly why there would be discretion to say, yeah, the next judge can come and say there's enough. This seems different than talking about someone's qualifications and will we allow expert testimony. It seems different than saying you absolutely must have expert testimony. We know you have to have expert testimony. If you're suing an anesthesiologist, you have to have an anesthesiologist. That's a matter of law. There's no discretion on that. But this seems different, and it seems odd to say another judge could conclude that, nope, a reasonable juror could could look at this and say that that's not an adequate warning?
Well, I say that only, Your Honor, to emphasize the point that a matter of difference of judicial opinion is not an abuse of discretion. It doesn't reach that point where you can overturn a decision just because maybe you would have made a different call on a
But
different
that goes
day.
back to my question, is if it's a matter of law, then we're reviewing that de novo, not abuse of discretion. If whether an expert's required is a matter of law, that would be reviewed de novo, correct?
That's correct.
And the position on summary judgment, we definitely reviewed de novo whether there's sufficient evidence to take a case to a jury. And we're saying if there's this evidence that a jury could conclude did not put someone on notice, wouldn't that be a de novo review of that issue?
I would agree with that, Your Honor.
Thank you, counsel.
Thank you.
I'm sorry. Your time's up.
The appellee's time is up. You've used your 20 minutes.
Your Honor, if it please the court, I'd be very brief. Just a minute.
No, you've used 20 minutes. The time is up. Mr. Sherrill.
Thank you, Your Honor. Whether an expert is required has to be a question of law. It can't be discretionary because of what havoc that would raise and how the claimants could never.
So what about Warner?
The question of whether to permit expert testimony or to allow a late disclosure may be abuse of discretion. I don't think Warner stands for that proposition, Your Honor, that the court's decision as to when an expert is required is not reviewed de novo as a matter of law. It has to be. And here, there was no engineering claim. There was no design implicated. We didn't allege the adequacy of the bike-specific signs, which is what counsel for the appellee referenced might be an expert. We might need an expert to say where they were placed. That's a red herring. There were no bike-specific signs. And as the court pointed out, if there were bike-specific signs, a jury could likely use its common sense in evaluating whether their placement was reasonable. You wouldn't put a bike lane closed ahead sign 2 miles north of where the bike lane was closed because of the hazard. A jury could evaluate that, but here it's no moment. They didn't place the signs, and they were required, and their experts said they were required. And the TBM says shall. And so, yeah, if it isn't the standard of care, it's evidence of the standard of care that should have permitted Ellen to go to the jury. There's nothing complex about placing 3 bike signs. There's no sophisticated understanding of the principles of traffic control.
But you would agree they don't have to necessarily be bike signs specific. It could just be a barricade blocking the bike lane.
I submit, Your Honor, that because the TBM published by the city calls for 3 bike-specific signs.
You wouldn't argue that you're entitled to summary judgment based on what's in the TBM?
No. I would argue that that's a question of
that's
fact.
Evidence that can be considered that's not necessarily dispositive.
Correct, because it's a reasonable person standard. The reference to all of these other signs that are in the TBM is another red herring, because that's not what's at issue. We aren't complaining about the temporary traffic control, which was at issue in the United Fire case, which does implicate engineering judgment. Our contention is that to adequately close the bike lane, there were 3 signs that were required. They weren't installed or placed, and that doesn't require an expert to evaluate that claim. And the city, the claim against the city is separate and apart from that. I can't envision an expert specialty in which you would solicit testimony regarding the adequacy of a contractor's conduct over that hour-and-a-half lunch period. Someone should have put a cone in front of the bike, in front of the hole, or should have put a barricade right in front of it. The United Fire case that the courts have referenced, there's a quote from it that we cite. The road did not contain a sign in front of the drop-off stating road closed, or even a barrier in front of the drop-off. Nothing indicated that the road had ceased and had no through travel. No workers were present in the area and nothing was blocking, nothing at all. If you replace the word road with bike lane, we're on all fours with that decision in respects to the specifics. But even United Fire regarded temporary traffic control, which includes speed, lane width, and engineering judgment.
But didn't United Fire say you needed an expert?
United Fire said you didn't need an expert. United Fire said you didn't need an expert because
That was
right
because
in
there was
front
no
of-
sign.
at the hole, at where the road was closed. In United Fire, there were signs elsewhere, as there were here. I didn't address,
But we're saying there were signs here, and the adequacy there, the city's position is there were signs. They weren't bike lane specific, but there was at least arguably a warning with a barricade. That would fit within the United case saying that's when we want an expert. There was a warning of some kind. You're just saying that wasn't a warning close enough to the hole to.
that's what the United Fire case focused on, the location of the warnings relative to the hole. In United Fire, there were other parts of the temporary traffic control plan as well. Where the road ended, there was nothing. Like here, where the trench existed, there was nothing. The sufficiency of the other signs may be relevant and are relevant on issues of comparative fault, on whether the signs were sufficient in the absence of the required 3 signs to convey that the bike lane was closed, but they're questions of fact. And the jury should have resolved those questions of fact, not the trial judge. And lastly and briefly, 122602 permits a party to cure a deficiency, a claimant, when the trial judge believes expert testimony is needed. Here, Ellen was never given an opportunity to cure the deficiency that the court found. She was deprived of her 122602 right because it wasn't until summary judgment that Trafficade first alleged and disclosed it was licensed. And then it filed summary judgment 2 days later after having disclosed an expert on the final day. Ellen.
Thank you, counsel. Your time is up.
You're welcome, Your Honors. Thank you.
Thank you for your presentations. We will take this under advisement, issue our decision in due course, and we are adjourned.
Thank you.